The battle over immigration policy is now in the hands of the Supreme Court.
Justices heard arguments today in United States versus Texas, which asks whether Immigration and Customs Enforcement can focus on deporting immigrants who are deemed dangerous.
DHS Secretary Alejandro Mayorkas implemented the policy last year, citing lack of resources to expel everyone from the country who doesn't have proper authorization.
But critics argue the policy violates DHS's own guidelines and ignores other non-citizens who break immigration laws. The Supreme Court will also consider whether the move violates how federal agencies develop regulations.
For more on this case, I want to bring in Judge Vanessa Gilmore, a former federal judge for the Southern District of Texas. It's good to have you with us. So tell us, what will justices be looking at to determine if this policy is in violation of the Immigration and Nationality Act or the Administrative Procedures Act?
The secretary is trying to focus his resources to set immigration policy that is best suited to address the actual needs of immigration policy in the United States. That is to try to arrest, detain, and deport the persons that are deemed to be the most serious, terrorists and people accused of serious crimes and people that are causing problems at the border. The Supreme Court has asked the parties to look at three issues. One, whether or not the state of Texas even has standing or the right to bring this lawsuit. Two, whether or not the secretary setting this policy violates the Immigration and Nationality Act in any way. And then the third issue is whether or not a district judge has the right or the ability or authority to enact an order that would have the consequences of vacating this action nationwide.
So what are the potential implications, and how could the outcome of this case change how federal agencies create and implement policies?
One of the issues that is involved in the statute is whether or not the language that says the secretary shall take certain actions is mandatory or discretionary. And the issue is whether or not the secretary has the ability to look at the resources of a particular agency and make certain decisions based on the resources available. In this particular instance, we have some 11 million people in the United States illegally, and the Secretary of Homeland Security has about 6,000 enforcement officers to try to arrest, detain, and eventually deport those persons. The secretary made an informed decision about where those resources should be spent, and trying to change the language that says shall to make it mandatory as opposed to discretionary really ties the hands of the secretary and the agency in terms of trying to carry out its mission.
You know, you said that one of the considerations is whether the state of Texas even has standing in this case. It's actually the 29th, our producer tells us, challenge filed by Texas against the Biden administration policies. We're seeing a lot of upticks of states filing similar challenges. And there's some controversy about this, whether this is an effort to cap presidential executive powers, whether it is the states using federal courts for their own gain. What's your take on sort of the larger picture of what's happening in this federal versus state fight that's happening in the Supreme Court?
The efforts by states to try to sue administrations based on their disagreement with administrative guidelines and policies is a relatively new phenomena, one that has not been a part of the way that the judiciary has been utilized. It has a decidedly partisan sort of feel about it, in that they are seeking to, one, dismantle policies that they disagree with, but two, more importantly, sort of forum shop and judge shop for judges that they think would be particularly receptive to the issues that they've raised. And I think that that might be what happened in this particular instance, with Texas really looking to find a court that was likely to rule in its favor. I mean, this very issue has already come before the Sixth Circuit Court of Appeals in almost an identical case filed by the state of Arizona. And that court had already decided that, one, the state did not have standing to pursue this case. Two, that there was no actual violation of the rules of the Administrative Procedure Act by the secretary in implementing the policy. And three, that the court did not have the ability or the right to issue a nationwide injunction vacating the administrative policy. The Fifth Circuit acknowledged that this had already been ruled on recently by the Sixth Circuit, but then failed to address why, in fact, they were going to come up with a complete why they're different.
All right, Judge Vanessa Gilmore, really appreciate your insights on this. Thanks.
Thank you, Elaine and Lana.